Lokpal. Origin of Lokpal. In 1809, the institution of ombudsman was first established in Sweden. In 1962, it was adopted in New Zealand and Norway. In 1967, it was adopted in Britain and later by other countries of the world. In India, the concept of ombudsman was proposed by the then Law Minister Ashok Kumar in the early 60s. The term Lokpal was coined by Dr. Laxmi Mall Singhvi. It means defender or protector of people. In 1966, the first Administrative Reforms Commission, headed by Morarji Desai, pointed out the inadequacies in the system for redressal of citizens' grievances and recommended the need for setting up of two independent authorities, one at the center and the other for the state, to look into complaints against public functionaries. In 1968, Lokpal Bill was introduced in the 4th Lok Sabha but lapsed due to the dissolution of Lok Sabha. Prior to 2013, the bill was introduced 8 times, that is, in 71, 77, 85, 89, 96, 98, 2001, and twice in 2011, but met with failure. In 2002, the Commission to Review the Working of the Constitution, headed by M. N. Venkatachalaya, recommended the appointment of the Lokpal and Lok Ayukta. In 2005, the second Administrative Reforms Commission, headed by Veerappa Moily, recommended the establishment of Lokpal without delay. In 2011, the government formed a group of ministers chaired by Pranab Mukherjee to suggest measures to tackle corruption and examine the proposal of a Lokpal Bill. Anna Hazare's India Against Corruption movement put pressure on the Manmohan Singh's government at the centre, which resulted in the introduction of the Lokpal Bill on 4th August 2011. This was referred to the Parliamentary Standing Committee, and on its recommendation, the bill was withdrawn and revised and was again introduced in the Lok Sabha on December 2011, and on 27th December 2011, the bill was discussed and passed by the Lok Sabha with certain amendments. On 29th December 2011, the bill came up for discussion in the Rajya Sabha but remained inconclusive. On 21st May 2012, the bill was reintroduced in the Rajya Sabha, which referred the bill to the Select Committee of the Rajya Sabha, which presented its report on 23rd November 2012. The government accepted 14 of the 16 recommendations made by the Select Committee and amended the bill. The Rajya Sabha could not discuss the bill as the House was adjourned. The Rajya Sabha took up the bill for discussion on 17th December 2013 and it was passed. the Lok Sabha agreed to the amendments made by the Rajya Sabha. The bill received the President's assent on 1st Jan 2014. Need for Lokpal institution. The reasons are as follows. First, the administrative departments are riddled with outdated laws, delays, red tapeism, and corruption. Second, the agencies which keep a check on the administrative departments are not independent. For example, CBI or ED. Third, there is lack of transparency and accountability in the system. Fourth, the adoptions of license Raj led to strict government control and regulation of the economy. As a result, doing business in India was complicated and cumbersome. Thus, the establishment of the institution of Lokpal was an important decision which can play an important role to curb the menace of corruption. Features of Lokpal and Lok Ayukta Act. The Act 2013 provides for the establishment of Lokpal for the Union and Lok Ayukta for states. The Lok Ayukta will be set up through enactment of a law by the state legislature within 1 year from the commencement of the Act. The Lokpal is an anti-corruption authority at the centre which inquires into allegations of corruption against its public officials and ensures accountability of public officials. First point, composition. Lokpal is a multi-member body that consists of one chairman and a maximum of 8 members. The chairman is either the former Chief Justice of India or the former Judge of the Supreme Court, or an eminent person with impeccable integrity and outstanding ability, having special knowledge and expertise of minimum 25 years in matters of anti-corruption policy, public administration, vigilance, finance, including insurance and banking, law and management. Out of maximum 8 members, 4 are judicial members who are either former judge of a Supreme Court or a former Chief Justice of a High Court. Minimum 50% of the members should be from SC, ST, OBC, minorities and women. The remaining 4 are non-judicial members who must be eminent men with impeccable integrity and outstanding ability, having special knowledge and expertise of minimum 25 years in matters relating to anti-corruption policy, public administration, vigilance, finance, including insurance and banking, law and management. Second, qualifications. The qualifications are as follows. First, should be a citizen of India. Second, should not be less than 45 years of age. Third, selection. The Department of Personnel and Training provides names of candidates for appointment for the post of Lokpal. The search committee, consisting of 8 members, shortlist names of candidates given by Department of Personnel and Training. From this list, the selection committee consisting of the Prime Minister, Speaker of Lok Sabha, Leader of Opposition in Lok Sabha, Chief Justice of India, or a sitting Supreme Court judge nominated by the Chief Justice of India, eminent jurist nominated by the President on the basis of the recommendation of the first 4 members of the selection committee through consensus, select the members for the Lokpal. Fourth, appointment. The chairman and other members are appointed by the President on the recommendation of the selection committee. Fifth, procedure of removal. A petition signed by 100 MPs is moved before the President. The President refers the matter to the Supreme Court, which conducts an inquiry. The inquiry is conducted by a committee consisting of the Chief Justice of India and 2 senior-most judges of the Supreme Court. The President can remove the chairman and other members on the opinion of the Chief Justice of India on grounds of misbehavior, insolvency, corruption, paid employment outside office, or infirmity. The process must be completed within 3 months of a complaint. Sixth, vacant post. The office of the chairman and other members of the Lokpal becomes vacant on removal, death, or resignation addressed to the President of India. Seventh, tenure. The tenure of the chairman and other members is 5 years or till the age of 70 years, whichever is earlier. Lokpal is not eligible for reappointment, but other members are eligible to become the chairman. Eighth, conditions, salary and allowances. The conditions, salary and allowances of the chairman are same as that of the Chief Justice of India, and the other members is same as that of a judge of the Supreme Court. All expenses are charged on the Consolidated Fund of India. The conditions of service, salary and allowances cannot be varied to their disadvantage after their appointment. Jurisdiction and powers of Lokpal. The Lokpal has its own autonomous machinery to inquire and investigate the corruption cases. First one, the jurisdiction of the Lokpal includes the Prime Minister, Ministers, Members of Parliament, Group A, B, C, D officers and officials of central government. Second, all entities receiving donations from foreign source within the context of the Foreign Contribution Regulation Act in excess of rupees 10 lakhs per year are brought under the jurisdiction of Lokpal. Third, the Lokpal has the power of supervision and direction over any investigating agency, including the CBI, for cases referred to by the Lokpal. Fourth, the transfer of the CBI officers who are investigating cases referred by Lokpal can be done only with the approval of the Lokpal. Fifth, the Lokpal has the power to search and seize documents and can recommend the suspension of the accused. Sixth, the Lokpal has provisions for attachment and confiscation of property, assets, proceeds and receipts acquired by corrupt means, even if prosecution is pending. Seventh, the complaint cannot be made after the expiry of 7 years from the date on which the offence mentioned in the complaint is alleged to have been committed. 8th, there is timeline for preliminary inquiry, investigation and trial, and also of setting up of special courts. 9th, the Lokpal Act mandates that all public officials should furnish their assets and liabilities of themselves. 10th, the Lokpal has the power to give direction to prevent destruction of records during the preliminary inquiry. 11th, the inquiry wing of the Lokpal is vested with the powers of a civil court. 12th, Lokpal has the power to make recommendations regarding the transfer or suspension of public servants connected with allegations of corruption. 13th, the Lokpal jurisdiction does not include ministers and members of parliament in matters relating to speeches delivered in parliament or for a vote cast in parliament. 14th, the jurisdiction of the Lokpal includes every person who is or has been in charge, director, manager, secretary of a body or a society set up by the Act of Central Government, any society or body financed or controlled by the central government, any person involved in act of abating and bribe giving or bribe taking. Exemptions from the scrutiny of the Lokpal. The institutions which are not under the scrutiny of the Lokpal are as follows. First, the Election Commission. Second, the Chief Justice and other judges of the Supreme Court. Third, the Armed Forces and Coast Guard. Fourth, all entities receiving donations from foreign sources in the context of Foreign Contribution Regulation Act, which are below rupees 10 lakh per year. Fifth, the Prime Minister's function with respect to international relations, national security, maintenance of public order, atomic energy and space. The Lokpal cannot inquire into corruption charge against Prime Minister unless a full bench of the Lokpal considers the initiation of a probe and at least 2/3 of the members approve it. The hearing should be held in camera, and if the complaint is dismissed, the records will not be published or made available to anyone. Drawbacks. The drawbacks are as follows. First, any false complaint is punishable with imprisonment for a term of 1 year and a fine up to 1 lakh. Second, there is violation of the principle of separation of powers, that is Lokpal, part of the executive, performs judicial functions. Third, the public disclosure of assets of spouses and dependent children of public servants has been cancelled. Fourth, the power of prior sanction with Lokpal has been nullified. Fifth, there is no provision for appeal, review or reconsideration of an order passed by Lokpal. Sixth, the Lokpal has no constitutional backing. Structure to assist the Lokpal. Lokpal discharges its functions through the two branches. First one, the administrative branch will be headed by an officer of the rank of secretary appointed by chairman from a panel of names prepared by the central government. Enquiry or investigation branch to be headed by the director of enquiry not below the rank of additional secretary to Government of India appointed by the chairman from a panel of names sent by the central government. Prosecution wing to be headed by the Director of Prosecution not below the rank of Additional Secretary to Government of India. Central Registry Scrutiny Wing, Establishment, Coordination, Media and Publication, Budget, Finances and Accounts. Second, the judicial branch will be headed by a judicial officer of appropriate level, will assist the Lokpal discharge their judicial functions. The appointment of officers and other staff of the Lokpal is made by the chairman or by member or officer of Lokpal as the chairman may direct. How a complaint can be filed and the steps followed for enquiry. The complaint can be filed electronically or by post or in person. In case it is filed electronically, its hard copy has to be submitted to the Lokpal within 15 days. The identity of the complainant or the accused official will be protected till the conclusion of inquiry or investigation. The Lokpal Act provides for the establishment of a body of Lokpal for the Union and Lok Ayukta for states to inquire into allegations of corruption under the Prevention of Corruption Act 1988 against public functionaries of the central government in a time-bound manner. The steps are as follows. First, when a complaint is received, the Lokpal orders A. Preliminary enquiry against any public servant by the enquiry wing or any agency including the Delhi Special Police Establishment, or make sure there is a prima facie case for proceeding in the matter, or B. Investigation by any agency including the Delhi Special Police Establishment when there exists a prima facie case. Second, in case the Lokpal decided to proceed with the preliminary enquiry of public servants, the matter is referred to the CBC. The CBC sends a report to Lokpal regarding officials belonging to Group A and B, and the Commission proceeds against Group C and D as per the provisions of the Central Vigilance Commission Act 2003. Third, the Lokpal, before ordering an investigation, should ask for an explanation from the public servant to determine whether there exists a prima facie case for investigation. Fourth, during the preliminary inquiry, the inquiry wing or any agency, including the Delhi Special Police Establishment, conducts a preliminary inquiry and collects all information and documents as well as obtains comments of the concerned public servant and competent authority before submitting a report to the Lokpal within 60 days from the date of receipt of the reference. Competent authority means for the Prime Minister it is the Lok Sabha. Fifth, the Lokpal bench consisting of not less than 3 members looks into the preliminary report and after giving an opportunity to the public servant to be heard, decides whether there exists a prima facie case and proceeds with any one of the following actions. A. Investigation by any agency or the Delhi Special Police Establishment. B. Initiate departmental proceedings or other appropriate action by a competent authority. C. Closure of the proceedings against the public servant and to proceed against the complainant if the allegations is false. Sentence up to 1 year in prison and a fine of up to 1 lakh rupees. The preliminary inquiry should be completed within 90 days of receipt of complaint. Sixth, in case the Lokpal decides to investigate, it directs any agency, including the Delhi Special Police Establishment, to carry out the investigation within a period of 6 months. The investigation report has to be filed in the court having appropriate jurisdiction and forward a copy of the report to the Lokpal. Seventh, the Lokpal bench consisting of not less than 3 members will look into the report and after obtaining the comments of the competent authority and the public servant may A. Grant sanction to the prosecution wing or investigating agency to file charge sheet or direct the closure of the report before the special court against the public servant. B. Direct the competent authority to initiate departmental proceedings or any other appropriate action against the concerned public servant.